Good, Cathaoirleach. Tánaiste, the paths in this House are well trodden by the captains of industry and sometimes by trade unions and their representatives. But my question to you, a bit like the question you were asked earlier about meeting the Debenhams workers, which maybe you could just clarify, but I believe you responded positively to that. My question to you would, in the light of the recent High Court judgment, which sent shockwaves through the industries affected by the judgment, would you be willing to meet representatives of construction, of contract cleaning and security, those most affected by that judgment?
Margaret, or English?
Sure, I'll be taking this question, if that's all right. Again, I want to thank Deputy Bríd Smith for raising this issue, and again, you've raised it in the House before as well, and you understand that we are appealing this decision as of confirmed with the Tánaiste last Thursday. So again, I want to reiterate that the Tánaiste's message at that time and again today on the questions to all workers and to employers affected by this decision in relation to sectoral employment orders, that until the appeal process is concluded and legal certainty has been obtained, there can be no unilateral diminution of the terms and conditions of employees by employers. With regard to contract cleaners and the other sectors that you've raised the issue with here today, they are covered by employment regulation orders, which is a slightly different part of the Industrial Relations Act 2015, and they're not impacted by this judgment directly. In relation to meeting with representatives of the workers governed by the Sectoral Employment Orders, I do intend to meet with the Irish Congress of Trade Union in the coming weeks to discuss this and other pressing matters, and we can take it from there. I'm happy to engage with you on this as well, but the important part here is that we appeal this when the appropriate time.
I welcome that you acknowledge that you will meet with the representatives in the next coming weeks, and I really do hugely welcome the announcement that the government are going to appeal the High Court decision, and I particularly enjoyed the Tánaiste's video that he put out on Twitter last night with Countess Markovic clearly having your back. I doubt if you're going to take her advice and leave your jewels in the bank and buy a revolver, but nevertheless you might follow her inspiration and show us that you do have the backs of the workers involved. And the reason I'm putting the question in this manner is because I think there's more to protecting and advocating workers' rights than just what goes on in the courts. There's also the ability of workers to defend themselves. So you have Plan A, where you would defend the rights in the courts, and Plan B, that the state would give workers the possibility of defending themselves. And here I'm talking about the legal right to trade union recognition, where if you have a high percentage or a certain percentage, like they have in other countries, of workers who join a union, then the employer must recognise them, must deal with them, must give them access to the workplace, which would prevent the sort of scandals we are alleged to have happened recently in meat plants during the COVID crisis, that sort of legislation that enable workers to defend themselves rather than always relying on the courts is also needed. It isn't just about appealing laws that we make here, it's about enabling workers to fight for themselves and defend themselves.
I think, Deputy, it's fair to say that as we've committed ourselves as ministers over the last probably 9 years to proving our work when it comes to industrial relations. I mean, that was quite a big act that came forward in 2015, the Industrial Relations Act 2015, and because we had previous that we had probably 15 or 16 years of discussion around here and legal cases and so on, and we tried to bring certainty to this, and we acted on that with that legislation at the time, and have built on that since, and we've shown absolute commitment. I think the minimum wage has been increased 4 or 5 different times over the last 9 years that we've been involved in government. But certainly when it comes to any cases, we've generally tried to strengthen the position of the employees and the workers, and naturally at all times you try to bring employers with us in that journey too, and to get that balance right, and that's what the legislation was about. I think at this stage it's important that we concentrate on our appeal and that we try to get that right, because the ruling in this case calls into question the constitutionality behind the regulations and the statutory instruments out of that legislation. So we'll concentrate on that over the weeks ahead. But naturally, both myself and the Tánaiste will be engaging with the trade union movements as well and trying to work on this as well in the weeks and months ahead. But I think there's no doubt in our commitment to this area.
Well, I absolutely agree that we need to very robustly defend or appeal the decision and defend the right of those workers to sectoral employment agreements, but I don't agree that this or consecutive governments have done their best to defend workers' rights. The lockout happened more than 100 years ago, and that lockout was all about trade union recognition. We still don't have it in this country, and several bills came before the last government that were delayed and held up and never progressed through the stages that they should have. No doubt we'll be submitting similar bills in this term. But workers need the right to be able to organise themselves and defend themselves. They cannot consistently rely on the courts to do so. And therefore, I want to refute what you said, that this government has always had, or previous governments has always had, the interests of workers at heart. So we need to look at the Cahill Duffy report in the case of Debenhams. It's going to repeat itself in other cases. And we need to look at giving workers the ability to organise, for trade unions to have access to workplaces like meat plants, like other areas of work where there's very contentious issues. Construction sites are notoriously bad for bogus self-employment and for precarious work, for low pay, and that needs to change as well. So it does mean a commitment from you for robust legislation so that workers can organise and defend themselves instead of just relying on the courts.
Again, just in short, we have a number of agencies working under our department and with our department officials who are involved in workers' rights and giving those protections and following through and all the legislation we bring in here, and that's the focus of a lot of our work. You mentioned various reports here. Again, our officials naturally work through all those reports and bring forward the changes when required. And I think the machinery and the arms of the state when it comes to employees' rights are very, very strong, and we're proud of that, and we will protect that. And you say you'll bring forward bills. We're happy to engage with you on those bills as time goes on. And again, it's about getting that balance right. But I think we're all committed to protecting workers' rights, and that's why we will be launching this appeal when it's appropriate time to do that.